Basically, courts are charging all caps name, which is a trust. They hope that you will identify yourself as the trust and give them access to the trust via your signature. In the corporate matrix, everything is held in a public trust, and the way the elite get access to the trust is to charge the trust and then get you to admit that you are the trust/name. During their frustration over our not admitting to being a trust name, the trustee and/or executor of the trust, we ought to ask who they are. Before we go any further, I need to know who you are. Addressing the clerk of the court, the beneficiary of the Sestuy K Trust owned by the state, are you the Sestuy K Trust trustee who has appointed this judge as administrator and trustee of the constructive trust case number 12345? Did you also appoint the prosecutor as executor of this constructive trust? Then point to the judge, administrator, and trustee. So you are the trustee, then point to the prosecutor, and you are the executor, and I am the beneficiary. So now we know who's who and, as beneficiary, I authorize you to handle the accounting and dissolve this constructive trust. I now claim my body, so I am collapsing the Sestuy K Trust which you have charged, as there is no value in it. You have committed fraud against all laws. Most likely it will not get that far before the judge, administrator, trustee will order case dismissed, or, even more likely, the prosecutor, as he clings tightly into his checkbook, will say, we withdraw the charges. We have exposed their fraud of the Sestuy K Trust, which exists only on a presumption. Trusts are created only upon the conveyance of property and can exist only as long as there is value in the trust. But there is no value in the Sestuy K Trust, yet they continue to charge the trust. That is fraud. The alleged property is we, man and women, whom they have deemed to be incompetent, dead, abandoned, lost, bankrupt, or minors, but that is an illusion, so if we claim our title, the birth certificate, then we collapse the presumption that the trust has value. They're operating in fraud, something we've always known, but now we know how they do it. Our having exposed their fraud gives them only 3 options. 1. They can dissolve the Sestuy K Trust, the one for which the clerk of the court is beneficiary and from which she created a constructive trust, the case, for which she appointed the judge and prosecutor, which hold temporary liability as trustee and executor, respectively. But they cannot dissolve the Sestuy K Trust or the entire global system will collapse because they cannot exist without our energy which they obtain via that Sestuy K Trust. 2. They can enforce the existing rules of trust law, which means, as trustee, they can set off their debt and leave us alone. Now they know that we are onto their fraud, and every time they go into court to administer a trust account, they will not know if we are the one who will send them to jail. The trustee, judge, is the liable party who will go to jail, and the executor, prosecutor, is the one who enforces this. This is why they want us to take on both titles, because then, not only do we go to jail, but also by signing their paper we become the surety, trustee in breach, and enforce our own sentence. They cannot afford to violate the ecclesiastical canon laws out of fear of ending their careers, so they are again trapped with no place to run or hide. 3. They can dismiss the case before they even take the risk of our exposing their fraud, which also makes no sense because then their careers, again, come to a screeching halt. Knowledge, not procedure, is power. The means by which we have attempted to remedy our problems, inflicted upon us by the powers that be, have all been superficial, compared to the origins of all the black magic, superstition, satanic ritualism, trickery, mind control, and clandestine practices. Under commercial law, dating back to the Code of Uarnamu, around 2100 BC, the use of another's property without permission puts one into dishonor and makes him liable for any debts. So, our using UCC forms, bills of exchange, AFE, or bonds, and altering documents of the Roman system can create penalties, as this is trading and or using the property of a corporation we do not own. The birth certificate proves that the name is, in fact, the property of the corporation which issued it. We can do all the paper perfectly, but, in the end, without expressing the trust they say, sorry, you're not one of us. But now we get to inflict fear into them. When we are forced to go to court, knowing that the judge acts as the trustee and the prosecutor acts as executor/trustee of the Sestuy K Trust is empowering. It gives us 2 choices. If we wish to expose the fraud of presumptions by which the Sestuy K trust still exists, then the court is the perfect opportunity to get your remedy in the judge's chambers by expressing the trust, everything the judge says. Even if it sounds like a command, order, or sentence, is actually an offer which we can choose to decline. I do not consent. I do not accept your offer. This is a fundamental principle of testamentary trusts. The beneficiary can accept or decline what the trustee offers. It is a fact that the judge/trustee who issues a summons or arrest warrant will have to think long and hard. Am I willing to gamble that the man/woman who walks into my court might call me on my role of trustee and expose the fraud that the Sestuy K trusts are still in place? Constructive trust. 1. Trust created by operation of law against one who by actual or constructive fraud, by duress or by abuse of confidence, or by commission of wrong, or by any form of unconscionable conduct or other questionable means, has obtained or holds legal right to property which he should not, in equity and good conscience, hold and enjoy. 2. A constructive trust is a relationship with respect to property subjecting the person by whom the title to the property is held to an equitable duty to convey it to another on the ground that his acquisition or retention of the property is wrongful and that he would be unjustly enriched if he were permitted to retain the property. Think of how the judge and prosecutor obtains and holds legal right to your property, that belonging to the beneficiary, you. When they can get you to answer to the trust name in their court and thereby make you the trustee who assumes all liability and pays the fines and goes to jail, while they become the beneficiary for unlawful enrichment for their own personal gain. The only thing that dead, fictional entities want from us is our life energy, and they can only get that with our consent. They cannot function without us, so they want to get us into court to pay the debt which they created by charging the trust/name. Common law courts no longer exist. The case has nothing to do with live men and women or facts, so anyone who testifies, talks about the facts of the case is doomed. All courts operate in trust law, based upon ecclesiastical canon law, that manifests as commercial law, and we are in court to take the hit if they can get us to give them our consent. To do this, they use every trick in the book: intimidation, fear, threat, ridicule, rage, and even recesses to change the jurisdiction when they are losing, to make us admit that we are the name of the trust, the trustee, the one liable for administering the trust. Therefore, until now it has been a waste of our time and energy to go to a place where it is almost certain that you, the real man, will be stuck with the liability. We are told in our public school indoctrination that judges are impartial and have sworn an oath to this effect, that he must not favor the defendant or plaintiff. But experience shows otherwise, that he favors the plaintiff, a glaring conflict of interest. The prosecutor, judge, and clerk, the cleric, all work for the state, the owner and grantor of the Sestuy K Trust and the owner of your title, the birth certificate. The case is not about justice, it's about administering a trust. They represent a trust owned by the state, and if we are the beneficiary, the only two positions left are the executor and the trustee. The fact that they are operating in fraud gives them only three options. 1. They can dismiss the case before they risk their fraud being exposed. 2. Or they can set off the debt and leave us alone. Or 3. They can dissolve the Sestuy K Trust case, but they cannot dissolve the Sestuy K Trust itself, or the entire global system will collapse, for they cannot exist without our energy which they obtain via that Sestuy K Trust, and they do not want to disperse the trust funds to the beneficiary, who is you. Now that they know that we are onto their fraud, every time they go into court to administer a trust account, they will not know if we are ones who will send them to jail. The trustee/judge is the liable party who will go to jail, and the executor/prosecutor must enforce this. This is why they want us to accept both titles, executor/trustee. Then not only do we go to jail, but by signing their paper we become the executor who enforces our own sentence. They cannot afford to violate the ecclesiastical canon laws out of fear of ending their careers, so they are trapped with no place to run. So, what's a court clerk to do? Soon none of these thugs will take any cases because the risk is too great. This will be the end of the court system. Under commercial law, since the Code of UR Namu, Circa 2100 BCE, the use of another man's property without his permission puts the user into dishonor, making him liable for any accrued debts. So our use of UCC forms, bills of exchange, AFV or bonds, FRNs, and other documents of the Roman system can create penalties, for this is trading with and using property which we do not own, because the birth certificate name is the property of the corporation which issued it. We can process our papers perfectly, but in the end they say, sorry, you're not one of us because you're real, and we're not. We're a fiction. But now we get to inflict fear onto them instead. When we are forced into court, knowing that the judge is the trustee and the prosecutor is the executor of the Sestuike K Trust is empowering. It gives us two choices. We can expose the fraud of presumptions by which the Sestuike K Trust exists and have them dissolve it because the trustee is the judge sitting on the bench. Dissolving one Sestuike K Trust dissolves them all. We can know that everything the judge says, even if it sounds like an order, command, or a sentence, is an offer that we can refuse to accept by saying, I do not consent. I do not accept your offer. This is the key principle of testamentary trusts. The beneficiary can accept or decline the offers of the trustee. End report. People are beginning to understand that most people are controlled slaves. Our main goal